Good morning, everybody, and welcome to the First District. We have one case that will be argued this morning. If you could please rise when I state the case and tell me your readiness to proceed. In Re KM, and that's C-230541 and 542.
Jessica Moss on behalf of the appellant KM and ready to.
Thank you.
Norbert Wessels on behalf of the state of Ohio, I believe we're ready to proceed.
Thank you very much. And I will be keeping your time. Yellow light means you have about a minute left, and red light means that your time has expired. Would you like to reserve any time?
Yes, Your Honor, 3 minutes.
Okay. Whenever you're ready.
Morning, Your Honor. May it please the court. This case involves a complicated set of rulings where ultimately evidence was allowed in by the juvenile court regarding two issues. An allegation for when KM and MG were younger, when KM would have been too young to even consent, and pornography. In looking at the first assignment of error, KM did not open the door to either of these pieces of evidence. The past allegation regarding when KM and MG were younger, the state initially questioned MG during MG's testimony whether MG had ever talked to Detective Stoll. It wasn't about a certain date. No date of an interview with Detective Stoll was identified. And in the testimony, MG talked about couldn't remember whether he spoke to Detective Stoll. He went back and forth, did remember, didn't remember, and eventually there was a video shown of his interview an interview with Detective Stoll to try to refresh his recollection. That interview was not put into evidence. And then at the Mayerson interview, MG spoke about both recent and past events. And the Mayerson interview occurred in April, and as Detective Stoll indicated, that this was referred to police in April of 2022.
Counsel, so we're clear. The testimony or the evidence regarding the prior incident came in through the Mayerson and not through Detective Stoll's interview? Is that your position?
It came in first through Ms. Helton testifying based on what happened in the Mayerson interview. So during the questioning of Ms. Helton, there was a question asked of, did MG tell you he spoke to the police the week before? But that happened after.
And the trial court allowed the substantive answer to that testimony, or was that stricken?
The court allowed an answer to that.
Well, the court took numerous other measures to ensure that information like this did not come into the record in terms of other rulings that it was making to disallow 404B type evidence to come in. So even though this did come in, given the fact that the court did appear duly sensitive to this issue, how do we factor that in, assuming there's error from a harmless error perspective?
Sure, and I think this case is we can utilize the McDaniel case, but it's also different from McDaniel. We have the court allowing this to come in because of open door and some back and forth rulings, but denying 404, but then allowing it back in, again, based on the open door. And so that's distinguishable from McDaniel, where because of the open door, a answer was allowed to happen, and then the state sought to introduce 404B evidence through a copy of a conviction, and that was not allowed in. So there still had to be an analysis under 404B. And so whether a door is open, and we would contest that the door was not open to either of these events, there still has to be a 404B analysis. And not only did that not happen fully, but the court denied 404B, but still let this in.
With regard to the open door issue, from my review of the record, there was lots of conversation about the door opening issue with regard to the pornography question, but less so with respect to the prior incident with MG. Is it your position that the trial court allowed the substantive information about the prior incident into the record because defense counsel had opened the door on the prior incident?
Yes. So for the prior incident, and that's the one that came first in terms of the sequence of events at trial, it was solely about opening the door. There was no 404B analysis at that point in time when that was allowed to come in.
Where did that occur in the record? At what point did the trial court indicate it was allowing MG's substantive testimony or the information about the prior incident to come in because defense counsel opened the door?
That would have been right around page one. Let's see. I want to say it's about 118 in the June 8th, 2022 part of the transcript. I think actually between 115 and maybe 118.
Thank you.
And going back to the open door point, as you indicated, like there were questions to MG about whether MG spoke to the detective. And what if, and I realize this isn't what happened, but what if MG had said, yes, and I shared, this event with the detective? Like, is that, I'm trying to understand, like, what's enough to open the door or not enough to open the door?
Sure, and I think the question here in terms of this past alleged incident was, did he say this? And that was a yes or no answer. So unlike McDaniel, this wasn't allowing the door to be open to finish answering that question. That question was answered. And to answer your question, there was two charges in regarding MG. One, there was a dismissal after trial, and so the court was trying to figure out, which of these two related to what, but then you tied in this other allegation from before, and there was a clear confusion of the issues for the court, and back and forth as to, the defense attorney saying, no, we're confusing this, and the court saying, I think this goes, with one time frame and not the other. And so if MG were to talk about, and because this was asked of Ms. Hilton, not of MG, when this came in, this goes solely to only answering that question of, did he say this, yes or no?
And looking at the harmless error question, the trial court did give some explanation as to why it reached the ruling that it reached. And it made some credibility determinations regarding both of the children who testified in this case. And in making those credibility determinations, it relied upon both their in-court testimony as well as the Mayerson interviews, but it didn't reference any of these prior incidents or the pornography. So how do we consider what you've labeled the 404B with regard to how the trial court ultimately ruled in the case?
Sure. I think this is a case where there was not substantial evidence in either of these adjudications. There was no other witnesses, there was no physical evidence, and we also have conflicting information from MG about what he said in the Mayerson interview versus what his trial testimony was. His trial testimony was only about an alleged butt smack. In regard to LM, there was conflicting information of what she said, what MG saw when he came downstairs, her not indicating that MG ever came downstairs. And so in looking at this would have been the only way for the court to conceivably get there because of the lack of enough evidence, plus when you factor in issues regarding the Mayerson interview.
Well, let's talk about the issues regarding the Mayerson interview, because our court has several times, recognized that this does fall within the hearsay exception. And so how do you, what is your position with respect to those cases and how we've historically looked at this?
So there have been a variety of cases that look at, the interview isn't all for one or all for the other.
Sure.
Certainly it is a combination. But so for instance, in LM's case, you have the first 32 minutes of this interview where she is repeatedly asked over and over and denies nothing ever happened on 3 occasions. She emphatically denies anything ever happened. And then after getting after not getting the answer that she wanted, Ms. Creemans then tells her, we're here because your mother said that you were touched inappropriately. And it's only then where that she then brings up KM. And it is clear that at that point in time, because she has denied everything up until that point in time, Ms. Creemans was able to determine if there was any other needs that was clearly for an investigative purpose for LM after that 32-point mark. It was not for medical diagnosis or treatment. For MG, the information about talking to a doctor and MG knowing that came at about 20 minutes into that video, so it was not at the beginning. I know in the testimony of Ms. Helton, it appeared that she explained that right away, and that's where the court initially didn't allow it to come in, but then eventually did allow it to come in based on her testimony that she told MG. But MG did not know that it would have been for a medical diagnosis or treatment, and the only medical issue that he had was his arms being sore from doing push-ups. It also couldn't have been about referring him to therapy because he was already involved in therapy.
Well, I mean, even if he was already involved in therapy, that doesn't necessarily mean that it couldn't have been about more targeted therapy or a different therapist or something else, right? I mean, that's not out of the question, is it?
I think in the facts in this case, that there wouldn't have been any other purpose that would have been for referring for anything else.
Counsel, what you're describing with regard to what I'll just call coaching, for lack of a better word, in the interview, wouldn't that help your client as opposed to hurting him? And so how would we weigh that in looking at the potential harm or prejudice of the introduction of this evidence?
Well, I think the harm in the case of MG is that the trial testimony is only about this butt slap. And if you go to any sporting event, you're bound to see somebody slapping somebody else's butt, whether it's a coach or teammates. And so a butt slap does not necessarily mean that there's some sexual purpose, that it's not for sexual gratification or arousal. And when then the Mayerson is about alleges more than a butt slap, alleges touching, then that is what makes that different and why that would be prejudicial to KM.
Well, at trial, MG also testified in a non-specific way. I don't think at trial that he was able to give time and detail to it, but he did testify at trial that that KM touched his private part, and then it's the Mayerson interview that provides additional detail to when and where that happened. And then to hear you describe the Mayerson interview, there's plenty in there for the defense to latch on to explain why there was coaching. So why was that harmful?
So MG, in regard to the December 22nd, 2021, only said that this was a butt slap. There was another reference to, I think, pulling down pants, but there was no time period where that was alleged to have happened. So it was not specifically that this was about the December 22nd, and we have to be cautious here because of this prior allegation involving something when KM was, younger than the age to consent of, MG confusing something that may have allegedly happened when they were younger versus what's allegedly happened here, in addition to the other charge that was ultimately dismissed by the juvenile court.
Ms. Moss, if you want to reserve any time, your time is up.
Thank you, Your Honor. Just briefly, in regard to the manifest weight, this case is so on par with NRA LF in terms of the inconsistent statements, but also the confusion of the issues and not clear information, as well as the problems with the Mayerson interview. And if there are no more questions, I'll reserve the remainder of my time.
Thank you.
Morning. May it please the court and opposing counsel. Your Honors, I think maybe one of the important things to do here is to contextualize some of the things that the court had to consider when it went into this trial as a whole, something that I don't think was well brought up at the beginning of oral arguments, is that one is the age of the children involved. At the time that these Mayerson interviews took place, the two victims were, I believe they were 9 and 8 years old, respectively. And so when it comes to the determination of credibility, for example, that's something that has to be left up to the trier. And in fact, that's the juvenile court in this case. Specifically relating to the 404B evidence, and I think the transcript bears this out, that when it came to MG and his disclosure in April of 2022, he disclosed a number of incidents that took place between him and the appellant. That was the nature of the 404B motion that was originally raised and then prior to the trial withdrawn. The state had originally intended to try and introduce these. Ultimately, they decided to withdraw that motion because they recognized that these other incidents, such as the one that was initially adduced, was not relevant, and so they didn't attempt to include that, and in fact redacted it from State's Exhibit 2.
And doesn't that, as we're analyzing the 404B issue here, isn't that recognition problematic from the state's perspective? This is clearly prejudicial information that doesn't bear on the specifics of this case other than from a propensity standpoint.
Well, I think Your Honor's opinion is kind of the opinion that the court had as well when it ultimately decided not to include or to consider that evidence. So as I review the record, what I believe happened was, and I think it's borne out by the testimony that it happened at trial, was that the state redacted from its interview with MG any reference to anything that was not contained in the complaint. And today, if when the court reviews that exhibit, they'll see that any testimony that's not related to the complaint continues to be redacted from the exhibit that was accepted by the trial court.
What were the Mayerson interviews introduced for from the state's perspective?
I believe that they were introduced to provide credence and to the testimony. For the truth of the matter, I believe they were introduced to provide context and information from the victims to align with their court testimony. But also, I do believe that they were provided substantively for the trial court to consider as their disclosure of the allegations contained in the complaint.
So to bolster what the children were saying in court?
Yeah, I think they had multiple purposes in that sense. I think that they were provided for the court to consider, as well as to bolster their testimony in court to provide more context to what it was that they would testify to.
Was what the two child victims said in court sufficient for the conviction, or were the Mayersons necessary to supplement their testimony?
I don't recall exactly what the trial court found. I think that in order to provide the context through, I believe, LMs, as I sit here, I'm not exactly sure how I would weigh that testimony and that evidence. That would have been for the trier of the fact, but I believe that taken together, the court obviously found that they were sufficient. But I can't necessarily represent that without looking closer into that. I apologize. I think the point that I was ultimately making is, to Your Honor's question, was the information that was adduced, and I do believe the court did discuss on page 119 of the transcript both 404B and the opening of the door to the evidence, and then later makes a ruling on page, I believe it's 120, 121. I'd be wrong again, that's 122. The counsel for the state says that she was about him talking to police and the issues that were coming in disclosure. Defense counsel, when she opened the door to this questioning, was questioning Ms. Helton, the forensic.
And specifically, the question, and I don't have the verbatim question right in front of me, but the question essentially was about, was there a conversation with Detective Stoll? And I guess that seems like a pretty narrow question. Yes, there was, or no, there wasn't. How is that opening the door? Or maybe am I misremembering it?
As I recall and as I review defense counsel's questioning of Ms. Helton, I think it's clear that her questioning was geared towards whether or not this this individual had fabricated or was coached to provide this testimony, and to whether or not the disclosure, and defense counsel made it sort of the thrust of her argument, this idea that there was something faulty with the disclosure, whether it was because it was being coached or was because it was untimely. She was talking with counsel specifically about the disclosure, suggesting that the disclosure that he eventually gave as to the December incident, one of the ones contained in the complaint, wouldn't match up with some of the things that he testified. And she makes reference to the video itself as to portions that were originally redacted from I believe State's Exhibit 2. So as I see, and I think as the court was attempting to figure out, there was information, they were trying to get why it was that this victim had eventually came forward, and to the suggestion of defense counsel that it was only related to this one individual incident. I believe that the state was allowed to introduce discussion between Ms. Helton and the victim to further clarify the reasons for disclosure, because it wasn't just this one singular incident or the one contained in the complaint.
Okay.
Oh.
Do we know how the trial court used or weighed the prior incident, if at all?
It's our position that I don't believe that the trial court weighed it at all. As Your Honor has already pointed out, the trial court made no reference to it, specifically ordered that for example, it not be included in the ultimate version that it accepted as the exhibit, so there's no reference in State's Exhibit 2 of anything MG talked about that wasn't related to those incidents. The trial court also admonished itself that it would not be considering anything that was irrelevant. One of my purposes in stating the ages of the victims at the very beginning is because the court did have to try and suss out the meanings of what the kids were talking about. I would concede that it might have been difficult for it to do so, but not impossible. And I think ultimately the decision that the trial court made properly weighed the information that it had to weigh. And to that extent, I don't think there's any error that would have come through in what it is the court considered. That is to say, I don't believe there's any evidence that whether it's for the pornography or this other incident that happened when they were kids, I don't believe that the court considered it all. In fact, as you read some of the court's rulings on other motions, the court goes so far as to say, well, that happened years before, I'm not really considering that. Not in its decision, but throughout the course of the trial as it's attempting to suss through the information. As it relates to the second assignment of error, I don't see that there's any reason to distinguish this case from this court's previous rulings on the issues of whether or not a forensic interviewer does so for a medical purpose. I think that the evidence makes clear, both through the testimony of the children and of the interviewers, that this was done for a medical purpose. And it's also, as I review the evidence of the victims, it was clear that they believed it to be done for medical purposes as well.
How would you respond to your opposing counsel's argument that LM did not, in the interview, it was about a half hour before LM said anything happened after denying it first, and it was only to a leading question, your mom said that this happened?
I guess I would not characterize it necessarily as a denial upon my review of the video. I would say as well, and this was testified to by, I believe Cremines is the name of the forensic interviewer, that once again, this is a young child, I believe she was 8 years old at the time, who had to testify about a particularly triggering event that happened in her life. And ultimately, because the event also happened prior, perhaps was either confused or was not necessarily able to come forward with that information without being more succinctly prompted by the forensic interviewer, which is part of her job. I think ultimately that goes more towards the weight of that testimony as to the admissibility, but I certainly wouldn't describe it, given the context of the interview with a juvenile victim discussing what has been alleged as a sex crime.
Right, but I think that's kind of a little bit of my discomfort with just this video interview in general, which is the witness understandably is having difficulty testifying in court about like what happened, and I understand that. But then you go to this video, which is in a totally different environment and without a lawyer there, with being able to, and it didn't look like she was doing blatant leading or anything, but being able to extract evidence from the victim in a different way. And I'm just wondering, like, how does that sit with confrontation clause, all sorts of other kind of protections for the defendant, when the key evidence is in this interview rather than what's happening at trial?
Well, as far as the confrontation clause is, I don't believe is implicated, because I don't believe that the information that would have been adduced in that interview would have been testimonial. I do think that there is a difference, ultimately a difference for the trier of fact to make between something that could be described as a denial or perhaps a reluctancy. Someone may be reluctant to provide information because they're making it up. They also might be reluctant because it's particularly traumatic, which is ultimately what the trial court ended up ruling in its decision-making. I think that would, I mean, obviously my position is that that's a determination for the trial court, which it had to make. But I do think that there is additional evidence that was adduced between MG and LM that supports LM's specific series of events. MG testified that there was an incident in which he went down the stairs, found LM and the appellant on a bed together. Once LM begins to testify about the incident, you can watch the appellant's interview with police. He says, there was an incident in which I was on a bed alone with LM, although obviously he denies that there was any sort of inappropriate touching. So to the extent that there's a suggestion that her interview was improperly invoked or that she was making it, I do believe there's other corroborating evidence that the trial court was able to weigh when making its determination of that touching and the sexual nature of that touching. As to the third assignment error, I do believe that there's sufficient evidence for the trier of fact to infer a sexual purpose for arousal or gratification. We agree and concede in our brief that this is not like sexual conduct where there's an immediate inference, but I think taken together, the testimony of the witnesses, the interview, and the appellant's interview, there is sufficient information in order to, when everything is weighed in the light most favorable to the state, to support those adjudications. I don't believe they're against the manifest weight of the evidence. There wasn't much discussion originally about the pornography that was discussed, but much like the original incident, that was something that was also redacted from the original interview, was not brought up by the state, and I do believe the door was open to the discussion. I believe in both cases of the 404B evidence, the juvenile court properly limited the state in what it could talk about, and in doing so, ultimately, although that information was adduced, I don't believe it affected the judgment that the trial court made in a prejudicial way. If there's nothing else.
Is the state relying upon KM's supposed consumption of pornography to prove the sexual gratification, or is there other evidence in the record that would support that element?
I don't think we're relying on the pornographic, the fact that he watched pornography at all. I don't think it was brought up by the trial court in making its decision. I think, although it doesn't create an immediate inference, as opposing counsel did reference, there could be completely benign situations in which someone could slap someone's butt, but given the other testimony for both of the victims, the attempts to isolate them, the touchings of their private areas, I do think the court was able to rightfully infer a sexual purpose for arousal or gratification taken together with the context. I don't think we would be relying on the fact that possibly in the past the appellant viewed pornography in order to establish that element.
Okay,
Thank you.
Ms. Miles, you have about a minute and a half.
Just in response to the state's arguments, for the state to say that they only utilized what was contained in the complaint, that's one of the problems here, because the complaint wasn't specific, nor does it have to be, but because it wasn't clear what allegation that MG was referring to, there's no way to determine what the juvenile court relied on, and if they confused the issues, because it's clear that there was some confusion of the issues. And if this court would have done, or if the juvenile court would have done a proper 404 analysis with the 403 analysis, not only would this not have been a permissible purpose, but it also would have been prejudicial to KM. Remanding for a new trial would allow the juvenile court to alleviate any of this confusion and these concerns. We'd ask that this court reverse the juvenile court's decision and either vacate the adjudication or remand for a new trial. Thank you.
Thank you. Okay, that concludes all of our cases today. We will issue a timely decision on your case and have a great rest of your day.